Right, good morning everybody and welcome to those of you joining online and to the guys in the office, welcome to our weekly update. There seems to be plenty of case law this year, at least one a week. In fact, I think I've got slides prepared for the next 3 weeks based on case law. So I prepare these slides well in advance, so if I struggle it's because I prepared these slides like 2 or 3 weeks ago, so please bear with me. Right, but it is an important judgment. Handed down by the SCA, so it's very authoritative, and it deals actually with GAAR, which already when you go GAAR, everybody goes, oh, we're not going to deal with the GAAR. You know, the GAAR is very unique and very isolated, and indeed its application is sometimes not something that everybody gets to see. But for me, there's a bigger message in this judgment that is of more general application, and that talks to Section 42 2B notices, which we all know as the letters of audit findings. Right, for those of you online, I'm Nico, Managing Director of Unicus Tax. Please bear in mind that this training is intended for my staff, cannot be relied on by other people. For those of you joining online, it really is for your interest's sake only. All right, so the issue, like I said, in this judgment by the SCA is a GAAR assessment, right? Or let's put it this way, the bigger dispute was the application of the GAAR. But what the taxpayer took issue with here is the taxpayer took issue with the fact that what SARS had said in their ATJ notice as the basis for applying the GAAR and what they pleaded in their Rule 31 statement was not the same, right? So if you're not familiar with Section 80J, it's effectively the same thing as a Section 42 2B notice. So what SARS must do is if they want to apply the GAAR, they must go to the taxpayer and say, listen, taxpayer, here's the facts as I have it. This is why I want to apply the GAAR. This is what I want to do with you. You have an opportunity to respond before I raise the assessment. That sounds almost identical, right, to a letter of audit findings. Right? And so SARS had said one thing. And then when their Rule 31 statement fell, which is a very common thing for them to do, is they changed their story. Now, I'm not going to go into the detail of how the GAAR changed, how SARS changed their case, but the case SARS was making out was different, right? And the issue was, is that permissible? And that's what the SCA had to establish. So the question here is not about whether the GAAR assessment was competent or not. It was whether or not SARS could change the basis for their GAAR assessment when you compare what's in the Rule 31 to what was in the ATJ notice. And the court approaches this from an interesting angle because the taxpayer had raised a breach of Rule 31. You'll recall that Rule 31 says that SARS are not allowed to novate the factual legal basis for their assessment, right? But the court seems to approach it from a different angle first. It does touch on 30, but it's almost as an aside, right? Because the court says, no, hang on, let's look at the GAAR provisions, because therein lies SARS's powers, right? Rule 30 does not give SARS the power to raise assessments, right? The power to raise a GAAR assessment sits in the provisions of GAAR, sections 88 to whatever, right? And he says that that power is confined to Section 80, and in particular, Section 80J only allows SARS to change the reasons for the application of the GAAR before they issue the assessment. So the court goes effectively and says in the GAAR context, he says, but the empowering provision is the GAAR provisions, and that SARS therefore in their ATJ notice was exercising their power. They cannot exercise that power in a Rule 31 statement. It's not competent for them to do so. And besides, that would require a revised assessment. So it kind of goes on this, by the way, it's also not permissible in terms of Rule 30. But the main just actually of the court's conclusion is you can't change in your pleadings is because the empowering provision allows us to exercise that power at the point of issuing the ATJ notice, not 3 years later when we get to the tax court, right, by changing their case. Right, and the court said, well, in substance, when you look at this, the case SARS is pleading, and you look at what was in their ATJ notice, SARS is they're no longer defending the same case, right? It's an entirely different case. Now, to bring this closer to home, because GAAR is isolated and not everybody gets to deal with GAAR, most of you guys, at least, and I'm sure some of the guys joining online, have dealt with letters of audit findings before. And really, it is much the same thing, right? In fact, there was a case, and I'm sure I referred to it somewhere here, where SARS argued that a GAAR notice can also be a section 42.2b notice. It could be, it's so similar, the provisions, that it can be one notice, right? Right, but what does 42b do? 42.2b do, for those of you who don't know, it says that if SARS does an audit and they want to they identify adjustments of a material nature, then what they must do is they must first give the taxpayer notice, right? Typically in practice referred to as the letter of audit findings, not to be confused with the letter of finalization. The letter of finalization is an attempt by SARS to comply with section 96, which is supposed to set out the grounds for the assessment. Section 42 is the audit findings letter, where they set out the grounds for their proposed assessment, right? So they must set out the facts and the law on which they rely for proposing whatever assessment it is they want to make. At least that's what 42.2b says, and then 42.3 says the taxpayer has the opportunity to respond, right? Which, when you listen to that, sounds almost identical to what an ATJ notice is, right? And in fact, like I said earlier, in Trustees of the CC Trust case, SARS, in fact, itself argued that, save for the difference in the time period that the taxpayer has to respond, I think the ATJ notice is a bit longer period that you have to respond, whereas a 42.2b notice, you've got a shorter period to respond. But save for the different time period that the taxpayer has to respond, they serve exactly the same purpose. They are sufficiently similar, SARS argued, to be combined in one notice. Right. The High Court also recognises in the Trustees of the CC Trust, I almost said something else, I almost referred to a journal, right? The Trustees of the CC Trust recognise that both provisions, ATJ and 42, sees this kind of iterative process unfolding, which is really to give effect to administrative action that is lawful, reasonable and procedurally fair, right? In fact, the court, I forget the judgment, that said 42, similar with ATJ, is there to give effect to the right to procedurally fair administrative action, so that you get a chance to respond before the decision is taken against you. And so that you know what the case is that SARS wants to make against you. Not that they just go and make the case, right? And you are left with objecting. So it has to give you the response or the period to respond, right? And now, the issue or the point I want to make with this judgment, that's a little bit more relevant, I think, to what you guys are seeing and what the guys online might be seeing, is when a dispute, a tax dispute, following an audit, right? So let's say there's an audit, task does a 42, letter of audit findings, you respond, they pretend to look at it, they raise the assessment anyway, right? You object, they disallow the objection, you go to ADR, ADR is unsuccessful, you give notice of intention to proceed to litigation, and SARS's Rule 31 must be delivered, right? That's the process, generally, unless you skip ADR, right? But that's generally the process. So what you're supposed to do, and what this case I think supports, albeit that the court says the foundation is not Rule 30, it is Section 80J, I think the same principle applies. Is what you're supposed to do is go and ask yourself, when I look at what SARS said in their letter of audit findings, and I look at what SARS is saying in their Rule 31 statement, is it the same case, or are they changing it? And I'll tell you this, the reality is this: a SARS auditor does not have the time, in my view, to properly raise assessments, not all of them, right? They rush to raise assessments, and I see this often, right? And now when we get to court, it's no longer just pushing buttons on a computer. Now it's an actual assessment that has to be defended on actual facts and actual law. And that's when you see SARS's Rule 31 statement becomes a little bit more full, right? And I'm using full to be diplomatic. It becomes fuller because now you've got someone who's got the time to sit down, and remember, the legal officials in SARS, their clients are the auditors, right, who raise the assessments. Their clients, if you will, right, for lack of a better word, right? So they have to now go and defend whatever it is this auditor did. And the reality is, oftentimes, when you look at that Rule 31 statement, it's not the same as what was stated in the letter of audit findings, and indeed the finalization, because this goes further. I would argue that this goes as far as to say you must compare what is in the findings to the 31, not necessarily the finalization, right? Because even there, you often find a difference, a variance in the reasons, which I don't think is right. I think they're supposed to issue another 42 letter if they want to change it. I looked at a case, Mika, you and I sat in the console yesterday, where what was in the audit findings was a 50% penalty, and the finalization letter, 125% penalty. No opportunity again given to respond, right? And I can almost guarantee you, in that case, what's going to be in the Rule 31, because that's where they're at, is going to be materially different, to what was in the letter of audit findings. All right. So the point is this. The stuff that happened, and this is a common mistake that people who always pretend to say they're in tax dispute resolution, it's a common mistake that people make, is they tend to say, I'll only start with litigation, I only started now with Rule 31, so I'm just going to start here. Because the case is de novo, which is true. The court does hear the case de novo. But you cannot ignore, in fact, it will be a very big mistake to simply ignore what happened up to the point of the pleading, right? You have to go and look at the history of the case from inception to date. Because indeed, I think in Erasmus, the court also says that, and I think in BASF, which is the case I'm discussing in 2 weeks' time, I'm busy analyzing it now, right? The court is going to say, but we must read any legal document, including a pleading, including a judgment, we must read it in context and for purpose, right? So if you want to make the statement that SARS is defending a new assessment in their Rule 31, you're going to need the context of whatever happened up to that point and whatever the correspondence was, albeit not only that contained in the letter of audit findings, right? Which is, Mick, the point I made in yesterday's meeting with the client, to say, listen, I can see where this is going, because what they've said in their letter of audit findings and what they're going to say in the Rule 31, I can guarantee you is not going to be the same, and I guarantee you we're going to bring an application to have it struck. But then the question is, I cannot simply read in isolation what is in the audit findings and finalization. I must look at, did SARS not perhaps send the guy an email to say, listen, this is why we are holding you guilty of that. So yes, it's not strict compliance with Section 42, but in substance, the purpose of the requirement has been satisfied, because the taxpayer knows the case that he or she is supposed to, or that it is supposed to meet. I mean, there's another case recently where the taxpayer served, I think that's next week's session or the week after that, I forget which one is where. But there's a case where the taxpayer delivered a notice of intention to proceed on litigation, which you're supposed to deliver by virtue of the dispute address notice or the rules. You're supposed to deliver to tax court litigation at SARS.gov.za. The taxpayer delivered it via email to somewhere else. SARS 4 years later delivered their pleadings. And they said they don't need condemnation because the taxpayer didn't deliver the notice of intention to proceed to tax court litigation. It delivered it elsewhere, so it wasn't delivered. So SARS's period never started to run, right? And the court said, no, hang on. In substance, that notice was delivered, and indeed SARS knew, because SARS responded, say, we take note, your case has been allocated. So you can't say on that stricter sense who kind of go, but it's not delivered properly, so therefore it doesn't exist, right? So the point is you need to look at the context and what was in the 42 or the letter of audit findings before you go ahead. And these are the two most common areas that I would like to just highlight in this session, and it's something that you guys must be on the lookout for. Typically, in cases where there's understatement penalties, which is pretty much all the cases we work on, right? And in cases where there's prescription, this is a particular area that you need to watch out for when you get to pleadings. Because in 99.9% of the cases, and there was a tax court judgment late last year, or the year before last year, I forget, where this principle was confirmed, is in 99% of cases, SARS will simply allege some random behavior classification, right? I can make an understatement, I can make a finding, therefore you were grossly negligent, 125%, repeat case, 125% penalty. I can make a finding, therefore you misrepresented. By no stretch of the imagination is that the facts on which SARS intends to lift the veil of prescription or intends to impose an understatement penalty. It's not, it simply isn't, right? And the reality is, I don't think SARS has the capacity to properly go and consider what is the behavior that gave rise to this, and to make a proper behavior classification. And the same holds true, I think, with prescription in most cases. Because the way that the legislation envisages this process, and this is crucial for understatement penalties in prescription, is it envisages SARS do your audit, right? If it's an assessment that's prescribed, then you must go and dig deeper and ask the questions, why did I not assess this properly before? Taxpayer, why did you disclose that expense there and not there? Did you know that if you disclose it there, there's a high risk of detection, so you try to hide it? Yes, that's misrepresentation. But what they often do is, you claim something that's not deductible, therefore it's misrepresentation. I have a case now where SARS made the point to say, you are guilty of gross negligence, taxpayer, I'm imposing an understatement penalty for gross negligence, because Mika, and you must just help me, just correct me, because we had this consultation yesterday, but there's many things going on, is SARS said that effectively your failure to respond to multiple requests for information after we conducted the audit suggests to me that you were grossly negligent. People, that is not even close to a factual basis for gross negligence. You can't refer to matters happening after the return was filed to establish a behavior at the point the return was filed. They've made out no case for the imposition of understatement penalties, and who bears the burden of proof? SARS. So I can guarantee you what's going to happen in the Rule 31, a SARS legal official is going to look at that letter of audit findings or finalization letter and go, crap, I need to actually advance facts, right, on which to rely to justify a behavior classification of gross negligence, because I don't have it at the moment. And as soon as they do that, they're going to novate the factual basis for their assessment. We're going to have an application to have it struck, and their understatement penalty case will fall flat on its face, right? That's as simple as that. The same is true with prescription. We've got 2 cases pending at the moment where we did an application to strike, where SARS, of all places, in their Rule 33 statement, advanced new grounds for lifting the veil of prescription when they had none in their Rule 31 statement, because we pointed it out to them in their 32. And then they tried, in 33 it's even more impermissible than it is in a Rule 30, because the taxpayer doesn't have an opportunity to respond if you put it in the Rule 33. That's very prejudicial. So we're going to have that struck. So this is important. The point is this, is when you deal with a case that's on dispute, what happened before the assessment was raised, up to the point the assessment was raised, and well, in some instances even thereafter, is crucial, because you might in itself find a defense to support the taxpayer's case, right? Crucial in the context of understatement penalties, right? If SARS wants to, and everything I'm saying here might suggest that I'm saying that SARS cannot, if they want to say something new, they cannot raise that assessment. That's not what I'm saying. I'm saying they can, and the court also suggests that in Erasmus. It says you can do that, but not in pleadings. If SARS, you get to pleadings and you realize that you have a new case, actually, concede this one, right, and go and raise a new assessment, right? Go through 42 again, go through 92 again, and if you post prescription, go through 99 again, and try again through the mechanisms provided for in the TAA. You can't skip 42, 92, 96 by just pleading a new case in Rule 31. That defeats the purpose of those sections, right? So that's the point. I'm not saying that SARS can't do these things. I'm saying that they must go back and try again, right? And that's the crucial point in this judgment. Yes, it's a GAAR judgment, but I think that it goes further. If anything, it reminds us of 42.2b, and I think there's enough in there to say, but you can't novate the assessment, right?